before the court is State of Ohio versus Roderick v. Cross Jr. Each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, let me know just before you begin, and I'll try to keep track of time for you. The arguments are being visually and audibly recorded to be posted online. Please keep your voices up and stay behind the podium. I would caution you about using children's names, but I don't think that has anything to do with this case. So, Ms. Brown, did you want to?
I will reserve 5 minutes of my time.
All right.
Good morning, Your Honors. May it please the Court, Giovanna Bremke on behalf of Mr. Roderick Cross. There's two assignments of error, sufficiency and manifest weight. The facts are simple, you can tell in the brief. The U.S. Marshals came out to the residence looking for Mr. Cross. They were greeted by a female and there was also a male who identified as Brandon Keith. And that individual said there is a gun in the upstairs bedroom. There was a gun located and also an ID for Brandon Keith. It was a short trial. There were only 2 witnesses, and it resulted in a 12-month sentence. With convictions for weapons under disability. Again, as far as the sufficiency is concerned, there is a conviction for weapons under disability in violation of Res Code 2923-13A3, which is a felony of the 3rd degree. I rely on several cases in my brief. One is the Hardy case, and again, this goes back to the gun and whether there was possession of the gun and for purposes of weapons under disability. In the Hardy case, there was knowledge and access to a loaded rifle, but the court held that there was no exercise, dominion, or control until the individual later shot the gun. The possession didn't occur until the firing of that rifle.
Counsel, my recollection of the state's brief, and I'm sure I'll be corrected if I am incorrect, is that Mr. Cross indicated that was his firearm, and that was the purpose of him telling them after they entered the home, so that they knew, I guess, it was there and it was his. How does that play with the possession of the firearm charge?
Well, I knew you would ask this. And again, I still have the manifest weight argument. I think I know you guys like to separate them, but I think it kind of, they relate in this case because essentially what the state had presented was, we believe Mr. Cross did not testify, but his statements through the 2 officers that testified. And essentially they're saying, we believe Mr. Cross that this was his gun, but we don't believe him as far as identification is concerned. So his credibility is, whether Mr. Cross's statements alone are credible, again, I think goes more towards the manifest weight, but ties into the sufficiency because, other than the officer's testimony that he had exercised some kind of statement of ownership, he did not have access to the firearm. He was actually in the kitchen and the firearm was upstairs in a bedroom. So he wasn't nowhere near that firearm. There was testimony that there was, it's transcript page 34, there was no DNA testing, no fingerprinting. They didn't check the registration to see if it was registered to him. There was no other tie back to him. And so they're using his statements, which, again, the credibility is in question because they're believing part of what he says and the 2 convictions conflict if you're just basing it off of his credibility alone.
Okay, but going back to the sufficiency argument then, if the statute says no person shall knowingly acquire, have, carry, or use, if I'm the owner of it, but I don't actually have it in my possession, is there an argument that being the owner of that is not sufficient under this statute?
Well, I think and I tried to distinguish actual possession from constructive possession. And I don't think there's an argument that he had actual possession. They never saw him handle it. Again, it was in different floors of the house. The constructive possession, again, I think goes to the registration check, the DNA testing, the fingerprinting, which there was no evidence of that as well. So whether he had exercised some kind of dominion over that, some kind of ownership, whether he called it his or it was registered to his or he had handled it in the past, there was no evidence of that either. So I would argue also that there was no constructive possession. There's also identity fraud and criminal tools which relate to the ID that was found in the other individual's name. And the identity fraud, again, part of the elements are that you have to use another person's identifying information other than the name. He did not use any social security number or an address, anything else that are identifying as that individual. There was also no testimony that that individual did not give him permission to use his identity. As far as the criminal tools is concerned, there was no evidence really presented at all about this other individual, whether he lived there at one point and had left this identification at the residence, whether anything, and actually Mr. Cross never presented that identification. It was just found in the bedroom, I believe the same bedroom that the gun was found in. But he had never presented it as, this is who I am. It was just found. And so there really is no evidence, again, that Mr. Cross was accepting ownership of that identification card, that he presented it as if it was his. And I believe the court had made some statements in the Rule 29 hearing that it was a tough call as far as the criminal tools are concerned, because that identification was never presented. It was just found in the bedroom. As far as the manifest weight, and again, we got into this a little bit, but again, as far as the gun is concerned, so the only defense exhibit that was admitted was the proof that the female that was in the home was on probation and therefore prohibited from being around this firearm. So there, again, as far as my client's credibility goes, there is some motivation there, and the defense does a good job at presenting it as this is the motivation for Mr. Cross to take ownership of this firearm, even if it wasn't actually his, because she was on probation and he was trying to accept ownership in order to prevent her from getting in trouble. At that point, they were executing a warrant on him and he was going to go regardless. Again, the identification, there is no proof that that individual did not live there, that that ID was simply in the home. There could have been other IDs in the home, and does that mean every time there is other identification cards? I think it's a fine line between whether that identification card can be traced back to Mr. Cross. He never presented it. It was just found in that bedroom. Any questions? I'll reserve the rest of my time.
Again, may it please the court, Assistant Prosecuting Attorney Danielle Bearden on behalf of the state. Cross's convictions for having weapons under disability, identity fraud, and possessing criminal tools were supported by sufficient evidence, and the convictions were not against the manifest weight of the evidence. Background as to the facts, as Ms. Bronke said, the U.S. Marshals did arrive at Ms. Garcia's home to serve a warrant because they received credible evidence that the appellant was there, Mr. Cross, and she in fact opened the door and said, yeah, he's here. And so when he was met with the marshals, he tried to identify himself as Brandon Keith. He was persistent in that he was Brandon Keith. However, Deputy Fuller testified that he had prior dealings with Cross, and so he knew him not to be Brandon Keith, but knew him to be Cross. Eventually, he kept being confronted with the fact that, no, you're not Brandon Keith, you're Cross. And so ultimately, the Cross did admit, yes, that is who I am Roderick Cross, and he did admit that there was a firearm in the master bedroom. He told the officers exactly where it was located, and so when the officers went, they found it exactly where Cross had described the gun to be. Additionally, near the gun was also found other contraband, such as marijuana, digital scale, cash, and Brandon Keith's identification card, all which Cross claimed possession of. Cross is trying to argue that this 8th District Hardy case should show that he was not in possession of it. However, that case has very distinguishable facts, and very specific and kind of unique facts, in that the appellant in that case was working at a beverage store and a robbery occurred, and there was a firearm kept at the beverage shop, and robber grabs it, and the appellant grabs the gun back. The robber charges the appellant with a razor, and so the appellant ultimately shoots the robber, and the appellant ended up being charged with having weapons under disability. The 8th District, in looking at the case, said while the appellant did technically have the gun within the meaning of the statute, that's not what the General Assembly intended when they created the having weapons under disability statute. So I don't think that that case has any bearing on this case. Again, Cross admitted to ownership of the gun, told them where it was. It was found in the master bedroom with other items that he claimed belonged to him. He had access to it. As to the identity fraud, again, he gave the name of Brandon Keith. Deputy Fuller knew.
Counsel, as to that, opposing counsel during her argument said that identity fraud requires more than just giving a name. Do you have any comment on that?
In looking at the statute, the statute says that you cannot use someone else's identity to represent yourself as another person, and that's exactly what Cross did in this case. He knew the marshals were there to serve a warrant on him. He did not want to get arrested, and so he tried this thing of saying that he was someone else. He ultimately did admit who he was, which is why I think that his statements that here's where the gun is, here's all, that's my gun, why those are credible statements, because the gun was found where he said it was, and he ultimately did admit who he was, and that the items belonged to him. Also, the woman whose home it was, Miss Garcia, she also said that the gun was his.
But he never actually presented the ID and said, see, I'm showing you I'm Brandon Keith.
He did not present the ID to the officers. He just insisted to them that he was Brandon Keith until he realized that they weren't buying it.
So what was the state's evidence then in terms of the Brandon Keith identification card or license, whatever it was, being a criminal tool in this particular case?
So the officers found it. Again, it was located with a digital scale, cash, marijuana, and a firearm. And the defendant was holding himself out to the officers as Brandon Keith. And so based on that, if there was sufficient evidence for the court to find that he was in possession of a criminal tool and did have a purpose to use it criminally. I don't think there was any evidence to say that that wasn't the case. Again, he did claim ownership of that ID as well. And unless there's any other questions, for those reasons.
All right, thank you.
Thank you, Your Honor.
As far as the identification and the identity fraud, I would point out that revised code 291349B2, it specifically says that no person without the express or complied consent of the other person, and again, I previously said this, but I think it's important that Mr. Keith did not testify, so there's no evidence that he did not give consent to Mr. Cross to use his identification. And again, that they should not use any personal identifying information. And again, it's restated in B2, the 2 part of it. Again, it says personal identifying information.
Well, counsel, under section A of that section, says personal identifying information includes but is not limited to the following. The first thing they say is the name. So isn't the name sufficient?
I would argue that just use, first of all, there's no evidence, again, that there wasn't permission to use that name.
Isn't that an affirmative defense under the statute? I guess I'm saying if there's no evidence that that has been Mr. Cross's burden.
No, I believe that it's an element of the offense that there was, that there's proof that there was no consent from that individual. So I would definitely say that that would be the state's burden, that there was no consent, because it's expressly in the statute that there's not consent from the other individual. And I would also dispute the fact that Mr. Cross claimed possession or ownership over the ID. Again, I don't think that there's any testimony to that effect. Any other questions? Okay, thank you.
All right, thank you both for your presentations. The court will take the matter under advisement. We'll issue a written decision which will be mailed to both sides as well as posted on our website and at the Supreme Court.